So we're going to start now with our panel discussion. So I'd like to invite to join me on stage, please, Jan Bormans, CEO of the European Startup Network, Claudia Martínez Félix, Deputy Head of Unit from DG Grow in the European Commission, Peire Nadal, CEO and founder of Coolcasc, Todd Reves, Director of Building Respect for IP Division at the World Intellectual Property Organization, and last but not least, Salis, IP expert, Latin American IP SME Helpdesk. Thank you all very much for joining us. It is a packed panel, so we'll dive right in. Jan, let me start with you. Give us a quick introduction to yourself and the organization.
Okay, so thank you. So I'm Jan Bormans. I'm leading the European Startup Network. Basically, we are an NGO based in Brussels, uniquely representing all European national startup organizations. We do basically two things. The first thing is trying to explain to policymakers why startups are not just any other type of SME, that we have specific characteristics. We are pivoting, we are looking for our business model, and we have very specific funding needs. And I think we have been successful through our collaboration with DG Grow, through the SME Envoy network, but also working with the Commission itself and making sure we have the impact on the new European innovation agenda. And the second thing we do is we exchange best practices amongst our members. And thanks to our collaboration with EU IPO, IP starts to become important. And I guess that's why I'm here.
Thank you very much. Claudia, we heard from you yesterday, but you've got a slightly different take today. Put on your SME hat and tell us what you're doing.
Yes, thank you. In DG Grow, in the unit of intangible economy, we are also developing concrete policies to support SMEs. That's a big priority for the European Commission. And in particular, we are actually, together with the UIPO, developing what is called the SME Fund. And also in that context, looking at developing new services, including the IP enforcement voucher, that I'll speak more about it a bit later. Thank you.
Thank you. Peire, tell us about your organization and what you want to talk about today.
Hello, good morning. Thank you for the invitation here. I built my company back in 2007. I started from the very beginning, from an idea, developing everything, building up the trade brand, the patent, the designs, everything from the very first beginning. We do helmet covers as main product and also goggle covers. We are now in 32 countries selling our products. And I have the whole experience of what it is, the IP world in my own, I suffered this in my own body with counterfeiting and so on. On the other hand, I'm also vice president of the Spanish Sports Association. I've been in that charge since 2018. We have around 100 companies representing 500 brands in the Spanish Sport Association, and we give them support for exporting their goods and their brands to other countries, and we also give them advice and education on subjects like IP and any other information that they might need. Thank you.
Thank you very much. Now, Todd, we all know the WIPO, but tell us a bit about what you're working on.
Yes, thank you, Jennifer. And I'd like to thank the EU IPO and the Patent Office of the Republic of Bulgaria for inviting me to speak at this event. So the Building Respect for IP division is essentially, I think Alexandra kind of defined it really well yesterday. We address the supply and the demand side of IP infringement. So the supply side through enforcement, and the demand side by raising awareness. And one of the things which we'll talk about on this panel is how we can raise awareness among SMEs. The World Intellectual Property Organization is 193 member states, so I've got 194 bosses, basically, including my Director General. And we do a lot of work with member states trying to improve their legislation. So we provide legislative advice on a confidential demand basis. We also provide a lot of capacity building. We work with a lot of the other international organizations present here today, including EU IPO. So with that, I'll finish and we'll get into a lot more of the details as the panel progresses.
Well, Ellie, you're also involved in helping SMEs on a global stage, so tell us a bit more about that.
Thank you very much, Jennifer. Yes, I'm here representing the Latin American IP SMEs Helpdesk, which gives support to small and medium-sized enterprises from the European Union to both protect and enforce their IP rights in most of the Latin American countries. And how do we do this? By providing information, free information and services. These comprise, for example, free first line and confidential advice on intellectual property and also related matters by providing with materials, online resources, and training. So if your company wish to expand their business in the Latin American countries and you have any doubts in relation to patents, trademark, or designs or copyright, just email us and we are going to provide information about the IP rights in those countries.
Thank you very much. Peire, let me start with you and your SME point of view experience. What has that been when it comes to IP? Give us your story, if you like, and we can expand the conversation from there.
My story is quite a long story.
We don't have that long.
Because, as I've mentioned before, I started from the very best beginning. I just came up with an idea when I was in ski holidays with my kids, finding out that I needed to find something to distinguish them on the slopes. So I came out with something to put on the helmet, and that was a helmet cover. I got in contact with a law firm and I just asked them to find out if there was something similar at that time in the market, and there was nothing. So from that moment I started with building up everything, the company, the brand, the designs. I started with only 4 designs. And I started in the Spanish market. Afterwards, I started also to introduce the brand in some other European countries. And I also made some more designs, adding to the initial ones, because the brand and the product was becoming successful. But as far as I continued in this adventure, in this entrepreneur adventure, I realized that it was really important to register all my works, all my designs, because it was really easy to be copied, because it's a very simple product. It's a kind of fabric which it has different designs, but it's really, really easy to be copied. And this law firm, they advised me and they told me how to do this, and I relied on them, and everything was done properly, registering the categories that I needed to, registering, as I told, the brand, the designs. I advised at that moment that it was really expensive, because it was not only the register in Spain, because I had to register in the 28 countries of the European Union. And also I had to match this with my business plan in the company, because as far as the company grew up, I was planning to introduce my brand in some other countries, also outside from the European Union. And I realized that every new country needs a new registration. So that's a lot of money. It's also a large process, and it's not easy. So I'm happy, because in some cases I had the answer from some distributors or possible distributors in some countries, which only wanted to make business with me if I had the trade brand registered in their country. So that was, of course, an asset and helped me for the negotiations. But I must also say that it's very hard, because for a small company it's a lot of time, a lot of money, and you feel always as you are never done, because every 10 years you have to renew the registers, Every 5 years, you have to renew the designs, picking and choosing wisely which ones you think they are going to be the fast movers, because you cannot register everything because that's too expensive. So it's a kind of feeling as if it's something that will never end. And when you think that, okay, more or less everything's settled up, 2 days ago I received the email from my law firm saying, we now strongly recommend to register your brand in the metaverse. It was like, oh my God, are you kidding? So that's my experience.
Well, it's interesting. Yesterday we heard from Brandon Blacko, who is a startup as well, and spoke about similar points about getting that, knowledge that he started. Now, he was starting to collaborate with big companies, so that was what was pushing him to do it. Jan, I'm sure you must have heard this sort of story or similar stories from startups before. Tell us a bit about it.
Yes, so I think that startups, they face different phases. So they have the phase where they're discovering what they want to do, where they pivot a lot. And then they have the phase in simultaneously where they are looking for capital. So if you think about protecting, so being proactive, with startups, it's not always the awareness of IP is not always there. Although with deep tech, which is the new thing, and where I think startups are very well placed to put innovations to the market, the awareness, we could say, is a bit higher. The problem is in this phase, startups have to talk to a lot of people. They have to talk to supplier, partners, etc., which IP-wise is not always easy. Then also, if you are still not sure about your strategy, do you have to protect everything? Do you have to protect every single thing you are thinking about? Probably not. When you think about deep tech, additionally, you have the problem that the time to market becomes larger. The benefit of deep tech is that people are more aware that IP could be important. The problem is that the time you need to wait for your cash is longer because your time to market is longer. Looking at profiles of people in startups, they're not always IP aware. If you look at deep tech, you have more academics, so that's good in a sense because patents, etc., resonate. But then things like brand protection, design protection don't resonate at all. And this can also be very important. I happen to be in contact with a very successful and promising startup in Lisbon. It's very difficult to explain to them that they have to protect, that they need to have a good brand, that they need to protect the brand. And by coincidence, this week, unfortunately, 2 US companies that have less well-developed technology, they're making an enormous PR stunt. Finally, the problem of having resources, money and time stays the same, and because this period in deep tech becomes longer, I think we need more support. Yeah.
Well, Ellie, let me ask you, we're hearing from Peire and from Jan that support is needed, that understanding, but the burden of enforcing the IP rights tends to be on the holder of the rights. That's a big burden for an SME, and I know we're using SME and startup a little bit interchangeably, but try and prize out the difference from your perspective as well.
Yes, I'm not going to be original with my response because today, in these 2 days, we have repeated a word training, and I think that training is a key point. I also think that when we train, we have to train not only the companies, but also the people involved in the enforcement, like authorities, customs, police, courts. And it's not the same when we are talking about a small or medium-sized company than we are talking a big company. Spending 20,000, 30,000 euros in a lawsuit is very expensive for a small one. So I think that when we train the authorities in charge of enforcement, they must know the real needs of a small company. And second point that I want to point out is that, for example, I think that if we give real examples of good practices, it's going to stimulate the small companies to at the time of infringement to start legal actions against third parties.
Todd, similar sort of question to you. I mean, what else can be done? What more can we do? There are outreach programs, there are support packages, certainly within the EU. Yesterday, again, to come back to what Brando was saying, that he got a grant from the EU IPO that helped him to actually go down this path. But is there anything that you see as a gap that could be some sort of low-hanging fruit to support SMEs? Or is it all going to be tough to try and get the support that they need to them?
Well, thanks for the question. I mean, I think it's been said yesterday and today that protection and enforcement is incredibly expensive, and a lot of SMEs just can't afford it, or they're not thinking about it at the time of the inception of their idea, their company, or their company's ideas. One thing that we really try to do, we don't work directly, at least in my division, with SMEs, but we indirectly help them through the work that we do with the member states. So again, we try to build capacity among law enforcement officials. We help with legislative advice, trying to get the laws up to par so that the SMEs will have a good avenue to proceed if they do decide to protect and enforce, and I hope they do. One other thing that is kind of outside of my wheelhouse a little bit, and we were talking about, you know, the cost of filing trademark applications or patent applications in many jurisdictions. At the WIPO, we have the Patent Cooperation Treaty, we have the Madrid system, and we have the Hague system for designs, Madrid for trademarks. So this is a way for small and medium-sized enterprises as well as large companies to kind of use economy of scale and file their national application, send it through the WIPO systems, and kind of broadly apply for the rights in the various member states that are members of these agreements.
Well, Claudia, I mentioned that there was some support already available in the EU. And let's talk about the IP toolbox again. Tell us how that can specifically support SMEs.
Thank you for the question. Yes, there's been indeed a lot of support. But just before I go into toolbox, let me flag as well concrete policies that the Commission is doing in supporting SMEs, protecting and enforcing better their IP rights, because we're fully aware that lack of resources is an issue, but also lack of knowledge, because there is a lot of knowledge that is needed to understand what type of IP right do I need to protect, you know, the main features of my business, of my invention, of my product. So I think it's very important to really flag that from the Commission side, and also obviously in support with the different national IP offices with EU IPO, there's been an IP scan, for example, offered to companies so that they can actually help and get support on assessing, you see, their business model. Same, obviously, with the Helpdesks, which is also a service we heard from Ellie that it's been, you know, offered now for more than 20 years in Europe, but in third countries, and that's also a part of Go Push. I mean, together, of course, with the Commission, with different entities and experts around, and which is at the disposal of SMEs, so that they can actually call and have any query. I mean, I have some numbers already since a couple of years. We had more than 20,000 questions. I mean, 600 related to only enforcement matters when they see. So those are services that are out there to support SMEs. And what we see, of course, is when we regulate, we also always have to have SMEs in mind. We have the SME test that we are applying in all our legislative frameworks. We also have the, of course, the fees that we hear that are, you know, an important element. So I think it's important to flag in the course of legislations revisions, and notably the current revision of the designs legislation, which is in co-decision, is looking at actually lowering the fees for the union designs registration. I think that's also an important element that we are pushing forward from the Commission side. And then when it comes to the toolbox, and to reply to your question, From the IP enforcement angle, what we want to ensure is that we put the SMEs again in the core of our action. And that goes along with what was announced as well from President von der Leyen in the last State of the Union speech about a relief package that will in principle come after the summer. It's late payment directive. I think that's also a very important element for SMEs. And on that front, what we want is to have in the toolbox also new measures to support SMEs, and EU IPO, and that's where we're collaborating very closely, because the SME Fund is both, it's an initiative coordinated between the Commission and the EU IPO. We'll have an enforcement voucher. Alexander already mentioned it, hopefully pilot project already starting in September, but it will be specific for SMEs that see a risk of their rights being infringed, so that they can get advice, direct advice, and that should also support them financially in taking those measures. But we're also exploring, and we have launched studies on that front. EU IPO is also finalizing a study on that front, on one of the costs that we hear sometimes SMEs, depending on the country, because that's not harmonized, will have to address if the goods that are counterfeited have to be stored and have to be destroyed. That's also an important cost. Sometimes it ends up in the pockets of those brown right owners to pay those costs. And that's something we're exploring. Is it feasible to support SMEs on that front? I mean, that's also something we're looking at. And final third element that we want to include in this IP toolbox against counterfeiting initiative is also relating to an important element, which is trade secrets, obviously, because that's very important. And we have seen that cyber theft is heavily affecting as well SMEs. We have seen that it has a major impact, cyber attacks into the economy globally. I think it's 60 billion, I heard, economic damage that it's generating. And SMEs are also affected, and we want to give them means, information, and a toolkit that will be created with trainings for SMEs to better defend their confidential information, the trade secrets, from cyber theft. And that will be finalized with the support of contractors by May 2024. That will be out there. I'll stop here. Thanks.
Well, thank you, Claudia, because you raised this question of cyber threats or cyber theft. Jan, I'd like to get your thoughts on, you mentioned that there's a better knowledge in deep tech. Do you think there's a sort of a gap between what sort of a startup you are, or what sort of an SME you are, and your awareness rather, of your rights?
Yes, I do think so. It was mentioned in the keynote also that SMEs that protect IP have a better performance. We could ask the question about correlation and causality, because it could be that startups or SMEs that think better about their innovation strategy as a side product also apply for more patents and IP protection, and so that they perform better because they have the strategy. So it's an interesting aspect to think about. Another thing that I see as a trend is that deep tech innovation or other kind of innovations, they become more complex, so we need more collaborations. And startups, we collaborate with corporates, we cooperate with universities, and then we are not fighting the battle with the same weapons. We don't have IP departments, we don't have IP lawyers. So even if you are aware, if you are in deep tech, you still face the prospect that one of your partners is actually cheating on you and stealing from you. And there are different cases that I know about. That's not new. And so therefore maybe I look, what can we do about this? And so at policymakers, we could maybe have a code of conduct for universities and corporates. We could have a dashboard, maybe bottom up. We could shame them, you know, those that are not playing well, have a TripAdvisor for working well in the IP field. So to come back to your question, yes, I see that in deep tech there is more awareness about IP, maybe not on the brands and trademarks, as I said, but still we're not fighting the fight with same weapons, so we need help.
Ellie, you wanted to jump in?
Yes, I just want to make a short comment on Sean. When we talk about startups in deep tech field, what I see from my experience is that, and I'm talking about the patent perspective, we have some questions about, okay, how can I extend my patent protection for other countries? And we have the PCT, as Todd said. We have, if we consider Latin American countries, we have to take into account that some countries, relevant countries like Argentina, Uruguay, or Paraguay, do not form part of the PCT treaty. But what we see is that the first patent application has been drafted by the inventors and not by a professional. And sometimes what we see is the claims, which is the most important part of a patent, are very narrow. So if we want to block a competitor, this first patent application is not going to be enough. So when we talk about patents, we recommend the startups to look for professional advice, because if you make a mistake in trademarks, you still have time to modify the strategy. But in terms of patents, it's quite impossible.
A very, very brief reaction. I don't want to steal your time. So I fully agree with you. And I don't know if there are enough independent experts to help startups doing this, so maybe that's one thing. The second thing is, for I see another danger, yeah, is that startups that are originating from university have the patent drafted by the university, which will be very good, but then who owns the patent? Yeah? And there are universities in Europe which are very fair, but there are also others that are about me, and don't still understand that in an innovation ecosystem you need to go for win-wins. I was with the commissioner in Silicon Valley. You know, the advantage of such an ecosystem is that everyone in the ecosystem understands that, you know, if the universities win, the startups win, the VCs win. And in Europe, we still don't always think like this. So it's also an attitude and a mentality problem.
Yeah, if I may just add maybe something which is also helpful to bring awareness of the latest developments to precisely trying to address this issue. It relates to this IP due diligence exercise that the Commission, together with the UIPO, is trying to put forward, which is a list of IP specialists that can advise companies, universities, beneficiaries of the Horizon program, for which you know that there is a substantive, I think it's 10 billion euros that have been put forward in the last, for the 7 years that the program lasts, and that allows beneficiaries of those funds and grants to assess the IP dimension, how to protect it, get advice as well on that front, ownership of the IP right, and so that is now out there. There's been a call for express for interest for IP specialists to actually provide this as part of these services that it's granted in this under this EIC Horizon program Europe.
Peire, you said you got a notification from your lawyer suggesting that you start looking at the metaverse. Now, I think there was a slight groan from some people, but looking ahead is kind of one of those tricky things, staying abreast of new changes. But I'm also wondering whether, for smaller businesses, do they really only become aware of these potential issues once there's already a problem, once there's already an infringement? And I'm thinking particularly in things of like selling online outside the EU, which can be an issue. Can you give us your perspective on that? I mean, is it actually even a deterrent to expand your business onto online?
I think that, of course, we are aware because even we are small companies, we get advised and we try to get all that information. So yes, we are aware of what's going on and what's the better thing to do for the company and the registers that we should make. The problem is what I have mentioned before, the resources. The process also is always very large and not easy. And once you finish the complete registration and you are convinced that you have done the things properly and you are protected, then you find out that you have copies in the market. And then it's kind of disappointing because you have invested a lot of efforts, a lot of money on protecting everything, and then you need to start a fight to those against those counterfeiters. And in many cases, they used to be very big companies, very big chains. They realize and they note there is a product who is selling well in the market, and they don't mind if there's a big effort behind with a lot of people, like in my case, working 24/7. That it's not important for them. They just realize there is an economic opportunity, and they don't mind in copying those products. They know that maybe they will have to remove the products from the market, and maybe they will have to pay a penalty. But they make their numbers, and the benefit is bigger than what the penalties that they have. So they go ahead. And in that way, we feel like a little bit, we don't know what to do, and we feel, okay, we are not really protected.
Todd, I'd like you to reflect on this idea that, you know, some infringers or pirates may just view fines as a cost of doing business, or their illegal business, as it were. How do you tackle that? I mean, it's almost like the whack-a-mole scenario we were talking about yesterday.
It really is. I mean, once you're on to a particular counterfeiter or pirate, you figure out their business plan, they're moving on to the next opportunity. One of the things especially on piracy, and you know, I've been attending these conferences and workshops for the better part of the last 20 years, and I think they're great networking opportunities and also great opportunities to raise awareness. But I believe in a little bit more tangible solutions to the problems that are facing us. So one of the interesting things that we're doing at the WIPO is, the Director General Tang mentioned it yesterday, is on WIPO Alert. And that's addressing online piracy through advertising. So basically, WIPO is kind of in the middle with the database. We have authorized contributors, which are national authorities who upload lists of infringing websites. And then on the other end of the database are authorized users, ad agencies, ad networks that use that data to prevent the legitimate advertising from going to the infringing website. So basically, a follow the money approach in denying the illicit operators revenue. Now, we're actually going to extend that. We're looking at a pilot project right now to move into more the payment processors. And we had a great panel yesterday talking about with intermediaries, rights holders, and MasterCard. And so it'll be built on a similar platform where you've got a database in the middle that's maintained by WIPO, and then the rights holders on one end and the payment processors on the other. The payment processors will use those lists to basically deny services under their terms and conditions to those merchants that are selling either counterfeit goods or offering subscription-based pirated content online. So I think these initiatives will indirectly help SMEs in the long run. So stay tuned on that.
Yeah, I mean, that's what I was going to, I mean, a rising tide lifts all ships, but it's also taking some of the burden off SMEs. I'm looking at the Slido poll. Some of you have been putting in your thoughts. More people are very welcome to do, but if we have a look there, I mean, some of the phrases or words that are coming up are authentication of products, practical information, increased turnover, collaboration, support or grants, information, financial support. But as you can see there, the largest by far is legal support. It seems to be what our audience thinks is most needed. Claudia, do you think that's fair? Would you have agreed with that as one of the big things you would have put up there?
Legal support, certainly. Yes, that's one of the areas where we think that we need to put most of our efforts to help SMEs get advice. Ideally, if financially even supporting them on that front, that's part of the encouragement we're doing when rolling out programs such as the SME Fund, the IP Fund, this new IP enforcement voucher that will come, obviously Helpdesk out there, the EN network, raising awareness, that are part of the actions where certainly Commission is focusing on.
Well, I also, because I wanted to move on to ask you whether part of that support is to help SMEs avoid becoming an IP infringer themselves inadvertently. Is that something that you're looking at?
Yes, thank you for that question. Yes, indeed, not only on the type of actions that I've already mentioned, but also I think it's important to look at what, from the regulatory framework perspective, we can actually offer to SMEs. And I would say, looking at the latest developments on IP, for example, on the side of the patent package, on inventions, on patents, which is certainly an area where we also see a lot of litigation, very costly litigation. Well, I would at least flag 2 or 3 important developments. First, the unitary patent system that that has entered into force and that will have, well, is now already up and running with a number of files already being filed, a unified patent court. We have heard, obviously, the fees being of concern, but that already, in terms of litigation, should support, SMEs, in terms that they can actually centralize litigations on that court. And at the same time, there is concrete provisions to support SMEs. For example, there is a 40% fees reduction for SMEs. And there are other potential measures to be rolled out for SMEs on that front. And if we look, for example, at the package that the Commission has proposed on patents, and we look, for example, at the proposal on standardization patents, which is one of the proposals that is intending to promote more transparency in the market, but also predictability when it comes to fair licensing terms. This is also of great help, and we had very concrete provisions for SMEs, notably with, for example, specific support measures, even financial fees reductions when it comes to the determination process for fair terms, for what we call also the conciliation as well center that will be made available when there is disagreement between the SEP holders and the SEP implementers, and SMEs may actually be tracked if they want to use that specific standard essential patent. And therefore, we see there already good movement preventing or at least supporting SMEs in litigation. And also, for example, and I think that's very important when we come with legislative frameworks in IP matters, that we increase transparency, and this is what we have done, for example, when looking at the pharma and the the pesticides, the plant protection products markets, where we have rolled out this new proposal for revising the SPCs, the supplementary protection certificates. There we see, for example, that we will increase transparency. So for SMEs that want to introduce, for example, generics into the market, they will have a much clearer overview of what type of supplementary protection certificates are actually protecting certain products so that they don't infringe those products, so that we increase transparency, and that certainly is of help of SMEs. And just maybe last point as well, I think is important for SMEs. The new, I have already mentioned it yesterday, scheme on protection for geographical indications for craft and industrial products, because this system, 80% of the beneficiaries are actually SMEs. So we have really micro companies, often it's even one artisan or a cluster of artisans that will be able to better protect their products, the names, which are, linked to that geographical indication. And we, in that context, foresee also in terms of litigation, the fact that by increasing revenues, they will be also better, positioned to protect from any counterfeit product that may be placed in the single market, and also enhancing their protection abroad in third countries. And I think that's a very important message to pass, also including when the products are in transit, because this is also, important not only for GIs, for craft industrial products, where we are introducing that additional dimension, but also for designs, because now designs will also be protected when the product is in transit, going to a third country. And I think that's also the second important element from an enforcement, also for the SME perspective. Thank you.
And I should also mention, just as another support, the EU IPO SME fund, the grant program that was set up post-COVID, is still available and running. I'm going to throw this open to the floor. Are there any questions that anyone has for our panelists at this point? If we have, I see one hand over here, please. We get a microphone. And in the meantime, we can see that things are changing behind us. People are now saying strong criminal penalties and boost prosecutions as possibly big help to SMEs as a deterrent. So we have our question.
Good morning. My name is Dimitris Kouzelis. I'm a European patent attorney, and I'm operating basically from Athens, Greece. I will come to a comment of the first speaker to your left, who talked about the ownership of the patents, especially when a patent is generated between a university lab and a company or a spin-off. We, in Greece, we are facing very often this system, and we try to change, actually, to adopt the best practice. And the best practice that we found up to now is based on another consideration. The problem is not only to whom does the patent belong, but also who is taking the decisions. Imagine you have an outside company, and you have a lab, in which lab there are 2 or 3 researchers, plus a professor, plus the technology transfer office. The decision-taking mechanism a lot of times kills the patent, because the patent has very strict timelines that have to be respected. So the best practice we found out was that the technology transfer office is the one who takes the decision, is the one who is the applicant, and the rights of the patent are regulated through a contract. In this way, the patent has a certain future, assured future, and also the interests of all parties are very well guaranteed, very well preserved. Thank you.
Thank you for that. Jan, I mean, it's an experience from Greece. How do you find that?
So I acknowledge and agree with a lot of the statements said. I think it's certainly a step in the right direction, but maybe you could even go a step higher. I think it's at the University of Irvine. So the money this university gets from the public authorities is partially dependent of the success of their spin-offs. Yeah? So it also means that their technology office will not only think about their own interest, but will think also about the interest of the spin-offs. And then you start to get this win-win ecosystem thinking. So I think it's what the gentleman said is very relevant, but we can complement it even better.
Thank you, and thank you for your comment and input. Anybody else want to add something? No one? No hands? I don't see any hands. Okay, well, I think in that case we'll come back to a sort of final round to wrap up. Again, I'm struck by how many people put in their thoughts on these Slido polls and how they change over the course of a conversation. Let's just a little bit speculate on this: strong penalties, boosting prosecutions. Ellie, sometimes with SMEs in particular, it can already be a threat of bankruptcy, or and if even a penalty may a little bit be shutting the stable door after the horse has bolted. It may not, in the end, actually change things for the SME. How do we think about that? How do we deal with that? Is the deterrent factor enough, or is it really about going after the infringers?
Well, I'm going to talk from the perspective of Latin America. You know that the report on the protection and enforcement of IP rights in third countries is part of the efforts of the Commission to strengthen the importance of the protection in third countries. I think that the last edition of that report was last month, in May of last month, and the first was published in 2006. And what I see is that in all the reports, some Latin American countries like Argentina, Mexico, Brazil, or Ecuador remains as in the priority list. So there are serious concerns from the Commission about the effective protection and enforcement of IP rights in those countries. Maybe I'm not going to be politically correct, and this is a personal view, but I see that there's a lack of dissuasive efforts from some authorities in some Latin American countries in order to improve the situation. I started working with the Latin American IP Helpdesk 9 years ago, and if I see my messages from the beginning until today, the concerns are almost the same. So that means that the situation has not changed in the way we want. So I think that I saw the word collaboration there. So I think that we needed to collaborate with Latin American authorities in order to change the situation. Because sometimes, and I was listening to Mar, it's quite difficult for a small company to really protect and even enforce their IP rights in Latin America. It's very difficult because you have to spend a lot of money that sometimes you don't have, you know.
Peire, let me ask you about just this international element of supply lines. I mean, is there any specific advice if there's that increasing the potential of infringement, the sort of disparate supply chains? How does that work?
That's the third part of the nightmare. Because then you go to produce to countries like China, for example, and then you are being copied by your own supplier. So in that way, I strongly recommend to have a special, not only NDA agreement, but an NNN agreement, which means that the supplier will not be able to go to your customers or to become your competitor. But although you can sign those kind of agreements, it's difficult, it's tough, because in my trips to China, I have realized sometimes looking for new suppliers that I arrive to the factory and I see a copy of one of my designs, which was already there. And I ask, what is this doing here? And I don't know how it arrived there, and they copied even the EN code, all the register code of that product. So I would recommend to pick with carefully the supplier and to sign an agreement in Chinese. Because sometimes they use that the contract is in English, and it's better to have the contract in Chinese to avoid misunderstandings and to be sure that it gets enforced in that country.
Well, to be honest, I would have rather finished on a slightly more positive note, but I am aware that there is coffee outside, and that I'm sure people want to get that before they get to their breakout sessions. We are going to take a coffee break now. Afterwards, we'll move into the 3 breakout sessions. Session 4, because we're following on from yesterday, will be putting technical innovation at the service of the global fight against IP crime. That will take place here in this plenary room. Session 5, Consumers' Health and Safety, will take place up to the right in Hall 3.1. and final breakout session, International Cooperation on Trade, will take place in Hall 3.2, which is up to your left. And we will go back into those in about 15 minutes. I will also remind the chairs of those sessions to please allow 5 minutes to get back here into the plenary room at the end for summing up. Have a great coffee, have a good network, and please a round of applause for our speakers.